Hello and welcome to Legalese. I'm Ernie Hyde, your host. The holiday season is upon us, and usually around this time of year I like to bring on some guests to talk about OUIs, operating under the influence of alcohol or intoxicating liquors or drugs. And I have with me two people today, Judge Michael Brooks from the Lawrence District Court, who has been on our show before. And welcome, Judge, again.
Thank you, Ernie.
And William Luppold, who is a detective sergeant with the Westford Police Department. And Bill, thanks for coming on again. So we're going to talk about OUIs. And in this particular show, we're going to talk about observation. We're going to talk about what the judge sees in the courtroom. And the next show we'll be talking about what defense lawyers do in OUI cases, because that will be sometime in the January timeframe, and we will have been through the holiday season, and hopefully we have absolutely nothing to talk about in January as far as OUIs are concerned. But knowing what I know over the years, that's probably not going to be the case. We will be talking about defense. So let's start off with the definition of OUI. Judge, why don't you give us an intoxicated or influence?
There's three elements. The person has to be operating a motor vehicle on a public way and either be under the influence of intoxicating liquor and or have a 0.08% blood alcohol or higher.
Okay.
That's an addition to the law a few years ago. It used to be the second one, the intoxicating liquors, is basically impaired operation, that your operation of the vehicle is impaired by the consumption of alcohol. And a few years ago, largely I think as a result of the federal laws, and in fact I think we were the last state that had called the per se statute, is that if your blood alcohol is 0.08% or greater, you are guilty of the offense of operating under the influence of intoxicating liquor. So those are the things that have to be shown. The first two, operation, sometimes an issue, public way, rarely an issue, and then of course the major issue is proving either impairment or the blood alcohol level.
Okay. And Detective, what are we looking for when we're on patrol now, knowing that you've been a detective for a while now, but before that you were a patrolman?
Correct.
And what are you looking for, especially this time of year, obviously? What are you looking for in the way of operation or the drunk driver?
Our guys are out there looking for, basically they're looking for any type of motor vehicle violation, but the ones they predominantly see that they're looking for an impaired driver, the marked lanes, the speeding, the stopped at a red light, it could be any one number of things, headlight, brake light. I'd say the majority of our OUI arrests are patrol related, from officers just making motor vehicle stops. Maybe it's, like I said, a plate light or a tail light or a headlight and they come across it. But the other half are people calling in. People on the road saying, hey, this guy's driving, he's all over the road, you need to get someone out here quick. And the others are the accidents.
Okay, and with the cell phones today, everyone has one.
Everybody has
so
one.
So you get 2 or 3 calls per car. You get plenty of help.
Absolutely.
Yeah. Okay, so as far as some of the things that you went through really quickly, people might not quite understand what you meant by headlight, taillights. And they might also not have understood what you meant by marked lanes.
Okay.
Now, just explain what you mean by marked lanes, because that's usually the biggest.
Right. Well, marked lanes, if there's a double solid yellow line and there's a fog line on the right, you're supposed to drive straight down the middle of the lane. Marked lanes is when the vehicle drifts over, across the double solid yellow line or across the fog line. Okay. And as far as the headlight or tail light, you're supposed to have 2 functioning of each. If you have one out or one's defective.
Okay. A lot of times I also see cases where it's pitch dark out.
And they don't have the headlights on.
And they don't have the headlights
yes.
on.
Right.
And here they are at 55 miles an hour in a 40-mile-an-hour zone. So, yeah, any of those things that would prompt you to stop a car ordinarily anyway can lead to someone who has been drinking.
Correct.
Right? Okay. And so talk about the level of intoxication in your experience. We all know that as long as your driving is considered to be impaired, you're intoxicated, according to the law.
Correct.
And so what do you look for when you're trying to determine whether somebody is actually intoxicated?
Now, we're looking at their physical appearance. We're looking for the red, glassy, bloodshot eyes, the thick and slurred speech, the they're fumbling around their wallet, the odor of an alcoholic beverage emanating from their breath and person, stuff like that. Can people have red, bloodshot, and glassy eyes? Sure, they might be tired, but are they going to smell like an alcoholic beverage, or are they going to be talking like their tongue's too big for their mouth? Some people will hand you, their union card,
Their
as opposed,
MasterCard.
a MasterCard as opposed to their license. But, you ask them for the license registration, they just stare at you. They just can't, they shouldn't be on the
Can't
road.
put it together. Yeah, okay. And how do you just distinguish when you make that stop or an officer makes that stop, whether, let's say you don't smell alcohol, but you do see some of these other signs that call into question drugs?
Sometimes you call in detection drugs, or it could be something else. I mean, maybe the person is tired. I mean, maybe there's something. They're diabetic. There's a medical condition. You want to try to ascertain as much as possible to figure out what you have there, so you can get them the proper help if they need it.
Right. Okay. So after you go through the observation of someone driving the motor vehicle, and it's not always driving, but by the way, right? I
No.
mean, they could be parked on the side of the road, sitting behind the wheel with the car running, and
Correct. You have
that's
operation.
operation, right? Okay. So when you get to the point where you think this person is intoxicated, what's the first thing that you do when you get them out of the car?
The officer will ask them to step out of the vehicle and perform field sobriety exercises to determine their level of sobriety.
Okay, let's explain this.
Basically, the divided attention test, coordination, and some other things that you want to have someone come out and do. The first one is horizontal gaze nystagmus, which I always tell a lot of people are a lot of big fancy words for checking someone's eyes. When you're under the influence of alcohol or drugs, your eyes have a jerk. It's involuntary. It's something you can't control at all. So we check for that, and then they have them do, I do it a certain way. I have them do the one-legged stand, which you have to hold your leg up for approximately 30 seconds, arms down at your side, count out loud from 1 to 30. The 9-step walk and turn. You walk 9 steps, heel to toe with your hands down at your sides, turn around and walk 9 steps back. The alphabet test, which is basically A to Z, and the finger to nose test, which I'm sure everyone's seen on TV or in the movies.
Most of which can't do it,
Yeah.
even if they haven't had a drink, right?
Sometimes.
But okay, I'm with you on that one. During all of these tests, by the way, they're also supposed to be counting.
Sometimes you have them. It all depends on the officer. Sometimes people,
Okay.
you ask people, is there any reason you couldn't perform these physical? Well, I had knee surgery, or I have a bad back.
Right,
Then
right.
you'd use a counting test. Can you count to 100? Yes, I can. How far? You'd ask them how far they've gone in school. Can you count to 100? Yes, I can. Can you count from say 38 to 72 for me?
Mm-hmm.
Something that you do what because some people just they don't want to, or they can't do certain things, whether they're trying to manipulate the system or not. But we have an answer for that, hopefully, with a different test.
Yeah. One of those different tests would be a portable breathalyzer, right?
Correct.
Okay, and so tell us what that is compared to the normal in-station sort of breathalyzer.
What is it? It's a portable breath test machine that's calibrated, just like the regular machine at the station. And officers, we have 2 of them. Officers will take them out on patrol, and they ask someone to take them. Usually, the way most officers do it is, and I don't want to say a jump ball, but for lack of a better phrase, if you're on the fence as to whether this person is impaired or not, and you are deciding whether you want to arrest them or put them back in the vehicle, you're going to ask them to take a portable breath test. Because like I said, they could be tired, they could have maybe taken some sleep medication, they could just have a diabetes. You can't figure out what's going on. You want to make that final determination to help you if they're impaired or not. So we'd ask them to take a portable breath test.
Okay, so that gives you a guideline.
Absolutely.
Judge, when you hear that sort of thing, do you ever hear about the portable?
No.
I
We don't
mean,
hear about the portable breath test in a trial setting. We might hear about it at a pretrial setting.
Pretrial.
But at a trial setting, you wouldn't hear about it. You'd hear about it in an arraignment, for example.
Right,
If there's
right.
some issue of conditions of release, such as don't drink alcohol or something like that, you might hear that they had a portable breath test reading of a certain amount.
Right.
Generally, that would not come into trial. You might have the regular breathalyzer, the machine at the station. We don't hear the HDN at all The reason we don't hear about the HGN test is it has to be proven with an expert, and police departments don't have the money to have experts come in for the high volume of OUIs that we have.
Right.
So in court, you never hear about the HGN test. It's good for the officer in making his determination. In fact, it's one of the best tests for the officer. But in court, I don't think I've ever, at a trial, it's ever been attempted to be offered. Because the officer himself can't testify to it because it's scientific evidence. You need an expert for that.
Right. Even though I think I've heard officers testify to observations while giving the test.
Well, that's
You're not really getting the result of the test,
Right.
but you're getting observations out of that test.
They can't follow the instructions, but like
Either that or they're going
right. Well, like Judge Brooks said, it's
back and forth.
the scientific principle, and I don't understand all of it behind it. I just know that what I see, and it's the only test that you could have the best balance in the world. You can know the alphabet forwards, backwards, and sideways. It's the only test you can't fake because it's involuntary. Your body's going to do it.
Right, right,
It's ironic that it's the one that doesn't get offered into evidence, however.
right, right. And so, okay, so we determined that someone is intoxicated. What do you do next?
They're placed under arrest and transported to the station, and at the station, the officer in charge will advise them of all their rights. Their right to a breath test, their right to a comparison blood test, their statutory rights, right to a phone call, right to bail.
Okay, that sounds really nice and cushy, but it's not. Handcuffs,
Absolutely.
part of policy.
Handcuffs, absolutely. Behind the back, double
Right.
locked, back of the cruiser, which is a hard plastic seat,
Right.
due to the fact that if something happens back there, it's able to be cleaned out, the cruiser put back in
No,
service.
we won't go there.
No, we won't go there.
Doesn't happen that often.
Not that often, but it does happen. In the cell block, the holding cell is a wooden bench, and when you get put down in the cell, it's a cement slab. The lights stay on 24 hours a day, and it's one itchy wool blanket. It's definitely not the Westford Regency.
Well, let's hope not. Okay, so what happens to the car?
The car gets towed, and it's held.
All right, and the person who owns it eventually has to come and pay for everything?
Everything.
Towing
Sure,
charges,
towing.
storage?
I think the towing fees are set by the state, but I want to say it's just $90, $100 to just pick it up and drive it to the impound yard. And then if it's a Friday and you can't get it, they're not open Saturday, Sunday. I believe it's a $20 or $30 a day storage fee.
Yep, okay. So it gets to be
Very
expensive
expensive.
from the beginning. Okay, and are people who are arrested for OUI entitled to a phone call as most quote-unquote criminals are?
Absolutely.
Okay. And what's your experience been with, who do they wind up calling? Is it a lawyer? Is it a friend? Is it a family member? What?
Very
What's your
few
experience?
call lawyers
Yeah.
unless they have a personal friend who's a lawyer.
Sure.
We had one actually once call a doctor in the emergency room, and the doctor came out. That's the only time I've ever seen
Wow.
it. Came out from the Emerson Hospital to give him an examination because it was his right and that's what he wanted. But mostly they'll call a friend, or they just stay. If they
Okay.
know they're going to court the next morning, or they're going to wait, they don't want to wake anyone up at 2, 3 in the morning. They're like, "Can I wait?" And I don't know about other departments, but we'll let them make as many phone calls as they want because we don't want them any more there than they want to be.
They wanna be there.
We'd like to
Right.
get them on their way.
And they do. They have that opportunity, right, to be bailed out?
Absolutely. If the bail commissioner comes out, sets a bail, whether it's his fee and a little more, but they have absolutely the right to bail.
Yeah, okay. All right, good. So Judge, when you hear these cases, it's either at pretrial pleading time,
Well, I see them in arraignment,
of course.
where they're informed of the charges, the lawyer gets involved. There's a pretrial discovery process, and then frequently in OUIs there's a motion to suppress because there's a claim that the stop was unconstitutional. We all have a right to be free from unreasonable search and seizure, so the police officer has to have a reason to stop you. Now, a lot of people don't realize, for example, one of the things that I think you didn't mention, but is a common reason to stop, is the officer will run the plate. It's out there for a reason. It's not a private number.
Which is legitimate.
Completely legitimate. I actually had an attorney argue me the other day that it was not legitimate. You run the plate and the license has been suspended for that
Missed
operator.
some case law on that, I think.
I don't know. But so anyway, we're frequently hearing that either there was no reason, no constitutional reason to stop. Once the red light goes on or the blue light, that's a stop constitutionally. Then getting them out of the car is a second step in the process of, well, he had no right to ask him to get out of the car. Now that often is involved in charges other than OUIs. Usually with the OUI, if you have these observations, the officer has to have probable cause to believe the crime has been committed.
Right.
Yeah, and that has to be based on specific and articulable facts. That's the standard. So if he has, the observations that the sergeant mentions, that's going to be enough. But if he pulls the vehicle over and has no reason for having pulled it over, in theory, that would be a stop that you would suppress, and the case would effectively end there. Similarly, if you found that there was no reason to get them out of the vehicle, that we say, well, then everything after that is the case law says the fruits of the poisonous tree. If the tree is poisoned, the fruits are poisoned. So if the stop is bad, everything after the stop is bad. And then, of course, any statements made by the person to the officer. A lot of people think, well, gee, it can't be okay to say, have you had anything to drink tonight? But that's considered a appropriate threshold inquiry. Officers are allowed to make threshold inquiries of people. People think they have to be given their rights before they get any questions asked.
I get those all.
They don't. They do have to get their rights at a certain point when they're in custody, and it's a custodial interrogation. So these are all legal steps along the way, though, where objections could be raised or motions could be filed to suppress evidence. Eventually, if either the case will plead out and the person will come to an agreement with their attorney or them and the prosecutor to some kind of a disposition that they can agree on, or the case will go to trial. And it can go to trial before a judge or a jury, and in district court we have juries of 6 people. So
Now, pleading out at pretrial stage, which is typically when that happens.
correct.
Under Melanie's law, which went into effect in 2005.
I think
Anybody
so.
got a
Right,
grip on that
it's
one?
right-
I think
right-
it's
it's 2005
2005.
or
But
six.
anyway,
It's right around there.
yeah,
2006, I think.
2006, okay.
I think.
And so there's been some incentives put in the law for people to fess up,
To resolve their case quickly. Exactly.
resolve the case quickly.
But
What are some of those incentives?
Well, the sooner you admit to the charge, the sooner you can get your license back, basically.
Okay.
You can get either a hard
And that's the key.
well, to most people, that is
In
the
this
key to the
area,
case.
at least,
Yes.
that's
To
the
most
key.
people, the license is probably the most onerous penalty. For example, which I know we will discuss, is if you refuse to take the breathalyzer test,
180.
that's just 180 days loss of license, no matter whether you're found not guilty or guilty.
Right.
And that's 6 months. It's a long time to be without your driver's license.
Right. Yeah.
So,
If you're in Boston, not so much. But
correct. But if you live out in the
if you're
suburbs or in the rural
Groton,
area, it's
Westford, Littleton,
terrible not to have
it's
your driver's
terrible.
license.
Yeah, okay. But that's right. I mean, there have been some incentives put in the law to get them over. Let's not play around with
Right.
them, especially if you know you're guilty. Or if the goods are so onerous on the evidence, I should
Well,
say.
most
not the
cases,
goods,
most cases are resolved before trial. Most cases plead out. That's true of all cases, civil and criminal. They resolve before trial. The first offender statute here is, I think, a reasonable one. Although compared to other states, I think it's tough, but it's a reasonable one. You can, if you comply with the requirements of probation, the ultimate outcome of your case is that it would be dismissed. And again, you
Kind
can,
of.
kind of what?
Kind of dismissed.
Well, it's still on your record. It's just not. It's not a conviction.
Right, but it does count for the second one.
Yes, it does, and
Right.
that's
So
but that's
it's-
the only
that's
case.
what I mean by
That's
kind
the
of.
only charge where a continuance without a finding, which is that is it literally you continue the
Exactly.
case without a finding of guilt.
Right.
That counts as a first offense.
Right.
Even in all other charges, a case that's dismissed would not count.
Right, right.
But that's the way the legislature writes the laws, and that's the way they did it.
Yeah. Okay, so, okay, let's get back to, we're now at the station, and we're going through our rights being read to us and getting information on us and so on and so forth. Is that a time when police make further observations?
Absolutely. Our
And what are they?
Well, our officers in charge will make an observation of the same as the officer on the street. Now that we're not outside, we're in a confined area, they could still detect the strong odor of an alcoholic beverage. Under the lights, which are better in the booking area at 3 a.m. than they are out in the street, I did observe that his eyes were red, bloodshot, and glassy. When he spoke to me, I had to repeat myself several times before he understood. You know, I could still smell the odor of a alcoholic beverage. So they pretty much will emphasize the same things the officer out in the street made note of.
Okay. And what about answering questions, whether they're able to do that, or
They'll note that.
hesitant, or
Some officers they like to get, and you see a ton of police reports, and I know the judge sees a lot of them too. A lot of guys are just meat and potatoes, and the other guys are throwing he said, I asked him this question, and he answered this way. Other guys are like, I asked him several questions several times, and I had to repeat myself, or he wouldn't answer me.
Yep. Or he blurted out this, and I didn't ask him anything.
Right. I blurted out, I didn't do it.
Those seem to be the ones I get a lot. Okay, so consequences of a first-time OUI.
Well, if a case goes to trial, and the verdict is guilty, it has to be guilty. You cannot continue a case without a finding
At that
after a
stage.
trial.
Correct.
You used to be able to,
Right.
but the case law is clear now. You can't.
SJC says no.
No, so it's
Yep.
guilty. So that's right away a different effect on your license, because usually it's a year loss of license with a guilty finding.
Okay.
So that's why many cases plead out. That's another incentive of the statute.
Is it possible to give a 24D and
On a first
I'll
offense,
explain that,
Yeah.
but a 24D after a jury trial guilty?
I think. Well, you can't get a condition without a finding. You could get the
No, you
can
get a
the
guilty.
conditions.
You get a guilty
Yes,
in the
you, sure.
24D, right?
You can still make them do the program, I think.
Okay,
But behind that also is that a judge can make any conditions of probation that are reasonably related to the offense.
Yes.
So anything related to alcohol in this
So
case.
no drinking or...
You could do anything you wanted in theory.
Okay, all right. And so the first offense is, I don't think any of this is light, but the first offense is the lightest
Correct.
of the OUIs you're
Correct.
going to see.
24D
and
disposition is especially.
especially is 24D. And so that I can explain that a little bit, that's a first offenders program.
Correct. It's a special section of the Chapter 90, Section 24, capital D, which relates to a particular way of disposing first and second offense OUIs.
Yeah, and for our audience out there, if you haven't ever read 24D, you should go up on the internet and feel free to read that whenever you cannot sleep. And if you ever get through it, God love you.
They should let you know.
Yeah.
They'd be the only one.
They'll be the only one. Get through it and understand it. So at any rate, as time goes on though, and we tend to get a second OUI and a third OUI and a fourth OUI, and people think I'm crazy when I say this, but it happens.
Oh, significantly, sure.
The consequences are significantly different, would you
Significantly
say?
greater.
Okay.
Second offense generally and frequently, again, on a plea would be disposed of with usually a 2-week inpatient program required. That's a treatment program for substance abuse.
Not jail, but it's...
No, but it's also then 26 weeks of required aftercare. So that's half a year then of treatment that you have to participate in. It's also a lot of money in fines and probation
Oh, yeah.
supervision fees. So it's very expensive.
Yes.
The first offense, you do a program of 16 weeks, an alcohol education program. You generally also are ordered to go to what's called a brains at risk program, which is a really kind of a program that the police initially started running in terms of showing people what can happen to you if you drink and drive,
Right.
and the consequences,
Or
and the
someone-
horrific consequences. There's generally in a first offense $600 in court costs and fees. If you have an attorney, several thousand more. If you have a private attorney, you have whatever attorney fee you had. If you had a court-appointed attorney, there's a $65 per month probation supervision fee, and you have to stay out of trouble. No new offenses, and if you comply with all those conditions, you complete the program, you pay the money, stay out of trouble. At the end of a year, your case is dismissed. If you fail to comply, you could be subject to up to the maximum penalty for an OUI, which is 2.5 years in jail, which
Right.
is the highest penalty a district court can give out.
Right.
And then a second offense, you have again the 2 weeks inpatient and 26 weeks aftercare.
2-year loss of license.
2-year loss of license. And then a third offense involves, if you're convicted, a mandatory minimum jail sentence of 150 days. And so as I occasionally talk to the DA.
With an 8-year loss of license.
Yeah, and the loss of license then
so
becomes 10 years, and it's just,
It doesn't get better.
yeah, no, it doesn't get a lot. I mean, if you're getting a third offense OUI, though, you need to think about what's going on, I think, because you're talking mandatory minimum jail sentence.
Right.
That's just the minimum. You could get more.
Sure.
If someone's hurt when you're
Count on getting more.
OUI,
Count
you're
on
talking a
getting
whole other charge, and I mean, OUI with serious injury is a very, very serious offense, and so.
Okay.
Can I mention one other thing?
Sure.
As I said,
Absolutely.
you're also, your license is suspended on the first offense for 45 to 90 days on an OUI, on a 24D disposition.
Right.
If you drive while
In
that's
addition to the 180 if you didn't take the breathalyzer.
yes. And if you drive while that suspension is in effect,
Oh, yes.
and you are convicted of doing that, that's a mandatory minimum 60 days in jail.
Right.
So-
That's a good point.
Yeah.
Okay. And so in a jury trial, not to belabor the subject, but in a jury trial, we have a two-phase jury trial if it's a multiple OUI.
Correct.
Correct? And the first part of that jury trial is for the purpose of what?
Is whether the person committed the offense of operating under the influence.
This time.
Yes,
Okay.
as if it were a first offense.
Okay. And, right, exactly. And the second part of that is what?
Proving the subsequent offenses. And you have a right to a jury trial for that.
So if it is charged as an OUI second offense,
Right. The jury at the first part of the trial doesn't know there's a second offense. Obviously, you don't want people assuming just because they were convicted before,
First time,
they
they
did
got
it
another
again.
one.
So it's never admissible, and the juries don't know about it.
Right.
And then if they're convicted, they have a right to a jury trial on the issue of whether there was a subsequent offense.
right, okay.
And that can also be, the defendant doesn't have to contest that. The defendant could stipulate to that. And it would be up to the lawyer strategically to decide whether they wanted to make the Commonwealth go to trial. If they are sure that the Commonwealth can prove it, they may not want a trial or not. Depends. They could also have a bench trial that is just to the judge on that issue. But it would be up to the defense lawyer.
Yeah, it's more of a technical issue anyway than it is
Right.
for someone that's on a jury.
Correct.
Yeah, okay. So I think it's pretty safe to say, and everyone in this room, including me, would say that getting arrested for an OUI is, number one, not a pleasant experience, and number two, comes with lifelong consequences.
I would agree with that.
Absolutely.
And on a second offense and beyond, even more so, especially when you have an ignition interlock device installed in your car for 2 years and you have to blow in it every
And pay
time
for
you
it.
start the car and pay for it and have it maintained and downloaded. And so it's a significant crime. And even though it's looked at as being not a big deal, it's a significant crime because it sometimes has more effect on you over your lifespan than some of the other crimes that people look at as being significant. Agree?
Correct.
Well, and I mean, I think the part that people often, and I think this is a common perspective, is you're driving around a 2-ton vehicle while intoxicated.
I know.
And the consequences of that to yourself and someone else could be, drastic.
Right.
And so, it's an offense that over time has developed from not much attention really from the criminal justice system 25 or 30 years ago to where we are now, where it's, I think people recognize what a big problem it is.
Okay. Well, I want to thank you both for coming on.
Thank you, Ernie.
It's again been a short 30 minutes. Actually, we're getting very close to the 30 minutes. And I just want to remind everyone out there that holiday season doesn't give you a license to drink and drive. And if you do that and you get caught, you are going to pay the consequences of that action. And you're not going to like them, I can assure you of that. Again, this show is brought to you by the Northern Middlesex Bar Association on a monthly basis, and I hope to see you the next time.